There's a folder in your filing cabinet with your name on it. Inside is a document you signed, got witnessed, maybe paid a notary for, and then never looked at again. You assume it will speak for you on the worst day of your life. It might not get read at all, not because there's anything wrong with it, because of 9 things nobody explained the day you signed. Reason 1, it doesn't do what you think it does. A living will is a healthcare document. It moves no money. It doesn't transfer your house or name a guardian for your kids. People hear the word will and assume their property is covered somewhere in there, and it just isn't. The 2 documents share a word and not much else. A last will and testament only starts working after you die, and it's addressed to a judge. A living will only works while you're alive, and it's addressed to a doctor. One is about what you own. The other is about your body. And here's the part that catches people off guard. A last will doesn't avoid probate. It guarantees it. It's a set of instructions written for a court, which means the court has to open a case, notify creditors, hear objections, and sign off on every step along the way. Meanwhile, hardly anyone has any of this handled. About a quarter of Americans report having a will. 13% have a living trust. Only about a third have named anybody at all to speak for them. Reason 2, the document has a switch, and most of the time the switch never gets flipped. It becomes effective only when 2 things are true at the same moment. You've lost the capacity to decide, and you have a condition your state's statute specifically names, usually terminal illness or permanent unconsciousness. Now think about the crises that actually land people in a hospital. A stroke you might come back from, a surgery that goes sideways at 4 in the morning, 6 weeks of delirium in an intensive care unit. None of those necessarily trip the switch, so your document sits in the chart, completely valid and completely asleep, which is the question underneath this entire video. If the paper is asleep, who's awake? Reason 3, you're being asked to predict a future you can't see. 2 researchers at the University of Michigan wrote the most cited critique of these documents ever published, and their verdict wasn't gentle. The policy has not produced results, they wrote, and it should be abandoned. Their argument was never that patients are careless about this. It's that no form on earth can anticipate the medical facts of a day that hasn't happened yet. Clinical guidance says the same thing in cooler language. A living will cannot realistically anticipate all the serious circumstances you may face. Reason 4, the paper isn't in the room. Clinicians say this outright. The document may not be available at the time and place it's needed. Yours is in a safe deposit box. The bank opens Monday, or sitting with a lawyer who retired to Arizona 4 years ago, or locked in a fireproof binder 40 minutes away while somebody makes a decision about you in 90 seconds. If nobody can produce it, it may as well not be written. Reason 5 is the one that stops the room, and honestly, it's the reason I wanted to make this video. Paramedics cannot honor it. Emergency medical technicians aren't able to act on advanced directives or medical powers of attorney, and once someone dials 911, that crew is required to stabilize and transport. So picture your family in the doorway holding out the folder. The crew is kind about it and completely unable to use it because a legal document is not a medical order. Compressions start, the doors close, and everything your mother wrote down stays technically true and practically irrelevant until a physician evaluates her at the hospital. The only paper that changes that morning is a physician-signed order, a portable medical order, or an out-of-hospital do not resuscitate order. Those carry the force of a medical order, and a crew has to follow them. That stretch from the driveway to the emergency department is where most of the pain in this subject lives, and almost nobody plans for it, because almost nobody knows it's there. Reason 6, you will change, and the document will not. Preferences move as an illness progresses, and they move as people's values shift. What a healthy 50-year-old swears she would never tolerate, a 68-year-old halfway through treatment may want very badly, and she isn't being inconsistent. She's being alive. Directions written with total confidence years ago were never meant for circumstances nobody imagined. In a real sense, you weren't signing for yourself. You were signing on behalf of somebody you haven't met yet. Reason 7, the words get argued over. Heroic measures. No reasonable hope of recovery. Phrases that feel completely obvious at a kitchen table dissolve at a bedside, where 2 people who love the same patient read them opposite ways. On February 25, 1990, Terry Schiavo collapsed at 26 years old and never came back. She had nothing in writing. Roughly 20 judges ruled on some piece of her case before life support was withdrawn on March 31, 2005. That's 15 years of courts and family arguing about what one silent woman would have wanted. This is where honest people disagree, and you deserve both sides of it. One camp says, stop promoting the living will altogether, and put every ounce of that effort into naming a person instead. Another camp points at that Florida case and says the exact opposite, that having nothing written down is what let the fight start in the first place. Clinical guidance splits the difference, saying the document can still give useful general direction, and that a plain statement of your values may serve better than a checklist of procedures. I lean toward that middle position, though I'll admit the Michigan critique has stayed with me longer than I expected. So hear me carefully. This is not never sign one. This is never lean on it alone. Reason 8, paper fights paper. Having several directives, or one that's a little too clever, can create real confusion. And when a living will and a healthcare power of attorney seem to contradict each other, somebody has to decide which one wins. It's usually a hospital attorney or an ethics committee, working from a document you're no longer able to explain. Reason 9 is the one that matters most. A living will give instructions. It doesn't give you an advocate. If nobody holds legal authority, hospitals fall back on default surrogate rules that change from state to state. And where the law runs out, a court appoints a guardian, sometimes a person who never met you. None of it touches a dollar of your property either. Aretha Franklin died in 2018 without a formal will. 3 handwritten documents surfaced afterward. And in July of 2023, 5 years after her death, a jury in Pontiac, Michigan validated the one found in her couch cushions. Scholars who studied 443 probate cases found the contested ones added around $17,000 in extra attorney fees on average. An ordinary uncontested probate already runs 3 to 7% of the estate. In California, the scale is written right into the statute. 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000. On $1 million estate, that's roughly $23,000 for the attorney, and typically the same again for the personal representative. Creditor periods run 3 months in Florida and a full year in Pennsylvania. Own property in 2 states, and your family gets 2 probates. Every month of that, somebody's grief is sitting on a court calendar waiting for a hearing date. What works instead is boring, and it works. Name a human being. A healthcare power of attorney reaches every medical decision, not just the last one, and it lets your agent move as the facts move. Choose someone who can hold their nerve in a hallway at 3 in the morning, which is not always the person you love most. Name a backup and ask them first, because this isn't a gift you hand somebody, it's a job you're asking them to take. Then put copies where they'll actually be found, with your doctors, with the hospital, in your permanent medical record. If you're seriously ill or frail, ask your physician about a portable medical order, because that's the paper an ambulance crew can act on. Add a durable financial power of attorney so nobody has to petition a court just to pay your mortgage while you're in a hospital bed. And for your property, fund a living trust. Because a will is not the exit from probate. It's the ticket in, then do the thing no form can do for you. Talk to them. Tell the person you named what a good day looks like. In your words, not in statute language. Tell them what you would trade and what you never would. Give them permission to change course when the facts change, because the facts will change. A directive your agent has heard you read aloud in your own kitchen is worth more than the most elegant document nobody has ever discussed. So go back to that folder in the filing cabinet. It isn't a plan, it's a preference. The plan is the person you name, the order your doctor signs, and the trust you actually fund. Paper doesn't argue for you at 2 in the morning. People do. Sign the document if you want it, then give it a voice. If you got something out of this, subscribe and click the next video on your screen to learn how inheritances in America work when real estate is involved.